Donc, nous sommes de retour. Merci au professeur Tuffrey-Wijne d'être avec nous aujourd'hui en direct de Londres. Donc, bienvenue et merci d'avoir accepté l'invitation. Donc, je vous cède la parole pour 20 minutes. Il y aura ensuite un échange avec les membres de la commission pour une période de 40 minutes. Donc, je vous cède maintenant la parole.
Oh, thank you very much for inviting me to present my evidence to this committee. My name is Irene Tuffrey-Wijne. I'm a professor of intellectual disability and palliative care at Kingston and St George's University in London in the UK. And in the next 20 minutes, I'm going to tell you who I am and what work I do. I'm going to define intellectual disability and autism just once more, and then I'm going to give you the evidence from my research as to what happens to people with an intellectual disability or autism in a situation where the law has been changed to allow euthanasia for them. But before I do that, I just want to put before you these fundamental questions. So the first one is that if there is a change in the law, where does your duty lie to be sure that the changed law is safer and better for your citizens than not changing the law? And also particularly, what is your duty of care to citizens who have a disability? So your duty of support, suicide prevention, trying to improve their quality of life, and at what point do you abandon those efforts and offer them an assisted death? So I speak to you today from my somewhat unique perspective as an expert in end-of-life care for people with intellectual disability or autism, and I'm the world's first professor in this subject. So I'd like to set out both the scope and the boundaries of my expertise. I'm a nurse. I have extensive clinical experience in both intellectual disability services and in palliative care services. And I've done about 20 years of research into the needs of people with an intellectual disability at the end of life. And it's also probably with regard to this debate, the assisted dying debate, important to point out that I am Dutch. I'm a citizen of the Netherlands. And I lived there, was born there until early adulthood. So I have detailed insight, including research-based insight into both the laws and the practice of euthanasia in the Netherlands in relation to people with an intellectual disability or autism, and that's what I'll draw on for this presentation. I'm not in a position to comment on assisted dying for people with psychiatric illness or indeed for any other groups of people in society other than those with intellectual disability or autism. So first of all, some definitions. So an intellectual disability is a lifelong condition that begins before adulthood, and it results in impaired intelligence, and people also have significantly reduced ability to cope independently. And it's a very, very broad spectrum. So people will need varying degrees of support throughout their lives. And autism spectrum disorder is a complex, also usually lifelong developmental disorder. And that's characterized by persistent difficulties with social communication, social interaction. So autistic people often find it more difficult to build and maintain friendships. And they also find it difficult to filter information. And they can be sort of oversensitive to sound or other sensory stimuli, for example. Another example is that autistic people can find it difficult to cope with changes of routine. And although autism is quite common among people with an intellectual disability, not all people with autism have intellectual disabilities as well. So Asperger's syndrome, for example, is a form of autism that's characterized by average or above average intelligence. So let me tell you now about my research, and the aim of this presentation is not to promote a particular side of the assisted dying argument, but to contribute to this debate by discussing the implications and including the risks for two particularly vulnerable patient groups. And I'm going to focus on three things now. The nature of the intolerable suffering that led to the euthanasia requests from people with intellectual disabilities or autism in the Netherlands, capacity and capacity assessments, and also a little bit about the nature of healthcare inequalities internationally. And you'll note that I use the term euthanasia, and that's because that's what's used in the Netherlands. It means a physician-administered death in response to a request from the patient to terminate their life. And physician-assisted suicide is also possible in the Netherlands and legal, but in over 96% of assisted dying cases, the patients in the Netherlands will opt for euthanasia rather than assisted suicide. So that's the term I'll use mostly. So case reports. We analysed 38 case reports of people who had mild intellectual disabilities or autism or both, and who died through physician-administered euthanasia between 2012 and 2020. And those case reports are publicly available on the Dutch Euthanasia Review Committee website. And you'll probably know all cases of euthanasia in the Netherlands are reported to a review committee who then scrutinise them, and that's typically over 6,000 a year, of which around 80 on average are published on their website, usually with a specific aim to show how the committee applied and interpreted the legal due care criteria for assisted dying and how they dealt with any particular challenges. And that's a fairly transparent reporting system. And that's, in my view, is unique in the world. And I think it's essential to have transparency in scrutiny and publication if you want to ensure patient safety. So in our analysis of these 38 cases, we focused on the question whether there were any particular difficulties when euthanasia legal due care criteria were applied to patients who had an intellectual disability or an autism spectrum disorder. And I refer you to our published papers, which if you'd like to know more details about our study. So first of all, intolerable suffering. My first examples illustrate our findings and considerations around this question: intolerable suffering without prospect of improvement, which is part of the Dutch due care criteria, sometimes also translated as suffering that's hopeless. In many cases, the suffering was described as not being able to keep up in society, feeling excluded from it, an inability to maintain relationships, depression, sadness, and distress about not being the person they would like to be, difficulty in coping with changing circumstances. People with autism had difficulty coping with what they experienced as an overload of stimuli, such as noise. And so, for example, here are some quotes, and the translation from the Dutch is my own. This is a man in his 70s who has a learning disability, intellectual disability, and autism, and who died through euthanasia in 2020. And this is the quote: "Because of his autism, he found it increasingly difficult to cope with the changes around him. As he got older, he became less able to cope and his anxiety increased, eventually leading to intolerable suffering." And here's another quote from a man in his 30s with Asperger's syndrome who died in 2014. "The patient suffered from the fact that he had a great need for closeness with others, whilst he couldn't maintain long-lasting social contacts. This was because he misjudged interactions and was inclined to behaviour that crossed boundaries." Now, the difficulty here is that these patients' suffering arose not from symptoms of an illness, but from the characteristics of autism or intellectual disability itself, as was the case for those who are highly dependent, who had difficulties with social functioning, difficulties in coping with social circumstances, or a tendency not to cooperate with treatments. And in a number of cases, physicians thought that further attempts at treatments or interventions were futile, as the patient wouldn't cope with it or simply would not cooperate. But intellectual disability, with its concomitant difficulties with social communication and relationships, could make it more difficult for patients to cope with the change that comes with ill health and aging, or to weigh information, or to understand and accept possible alternatives. And in many of these case summaries, the term suffering was used to describe the normal variations in behavior and perceptions that are seen in people with autism, which are an inherent part of that person. And I can give you many more examples of this. So there were statements about a lack of prospect of improvement, such as intractable symptoms, refractory to treatment, or palliative treatment. These sort of statements are actually meaningless in the context of lifelong disability. Autism is not a syndrome that can be palliated. So one question I'm raising is, to what extent do the characteristics of certain groups of people make them eligible for assisted dying? Or is the suffering described in these case reports in fact a result of society's failure to accommodate and support the needs and characteristics of people who have autism or an intellectual disability? Let's come to capacity assessment next. My next examples are to illustrate the difficulties with assessments of patients' decisional capacity and competence. One example was a woman with intellectual disabilities in her 30s who had a brain tumor in childhood, which had now been in remission for about 10 years. But she was now suffering from unexplained physical symptoms, which one psychiatrist thought might be due to sadness that her life hadn't turned out as she had hoped. And this psychiatrist found it difficult to assess her capacity because of her coping style, which consisted of crying, indicating that she didn't know. That made it difficult, very difficult, to ask further about her euthanasia request. But there was disagreement between physicians about this patient's capacity, which was not unusual in many of these case reports where a patient had an intellectual disability. But she was granted euthanasia in 2020 because of the consistency of her request and the fact that she could describe alternatives to euthanasia. And that was also not unusual. For example, a woman with intellectual disabilities in her 60s suffered from tinnitus, that is ringing in your ears. Her doctor had explained to her that most people learn to live with this, but, and now I quote again, because of her primitive thinking abilities, the patient was focused solely on eliminating the tinnitus completely. Once she realized, I'll never get rid of it, her suffering became intolerable and hopeless to her, and she was then only focused on euthanasia. And she remained focused on her euthanasia wish, partly due to her low level of intelligence. Now, a persistent request does not necessarily imply capacity, and in fact, it might even be indicative of a lack of capacity if the patient's intellectual disability leads to difficulties in considering or weighing up alternatives. And if stringent capacity assessment criteria were to be applied in this particular case, it may well be that this patient's inability to appreciate the significance of the information in relation to her own situation and to weigh up the treatment options would render her incapable to make a euthanasia decision, however persistent her request. And that takes me to the most commonly used and influential model for assessing whether a patient has the capacity to exercise autonomy in making healthcare choices. And that's the MacArthur model, which consists of 4 abilities, and that's also known as the Applebaum criteria, which is to understand the illness, the various treatment options and their potential benefits and risks, to appreciate the significance of that information and how it applies to themselves in their personal situation, to weigh up the options using reasoning and logic, and then to communicate a choice. And the difficulties that many people with intellectual disabilities have in rationally manipulating information with regard to their situation, the consequences of their decision, the possible alternatives, make them particularly vulnerable when the bar for capacity assessments is not set high. And of all 4 Applebaum criteria, the appreciation ability is undoubtedly the most difficult to understand and to measure. And the problem is that impairment of decision-making capacity lies on a continuum, but a judgment of decision-making capacity is an all or nothing concept. So either you have capacity to take a particular decision or you don't. And where on that continuum the cutoff point for competence lies is therefore a matter of judgment. And many people, including Applebaum himself, have argued that the stringency of capacity tests should vary directly with the seriousness of the likely consequences of the patient's decisions. And I would argue that euthanasia should only be open to those with a high degree of mental capacity to make such a request. And for a life or death decision such as this, the bar for capacity should be set high, and I'm happy to discuss that further with you if you wish. But finally, I just want to talk about health and social care inequalities, and I want to point out that we have to be extremely conscious of the possibility of diagnostic overshadowing. That means that there is a negative bias impacting on a clinician's judgment. And there is strong evidence from around the world that people with intellectual disability or autism have been poorly treated and even died unnecessarily due to poor decision-making by healthcare professionals. Numerous reports in recent years have suggested that the lives of people with an intellectual disability are valued less across society, and that their short life expectancy results from inappropriate, value-laden decision-making by healthcare professionals. And when we look at the Dutch case reports, it was mostly accepted by doctors that suffering could consist of psychological pain, dependency, social isolation, loneliness, and lack of coping mechanisms that were a result of intellectual disability or autism. There were also several examples of rigid thinking, where the patient was fixated on the idea of euthanasia and unable or unwilling to consider alternatives. And in the Netherlands, where most citizens are aware that they can ask for euthanasia if they feel that their suffering is hopeless, it is inevitable that people with intellectual disabilities or autism can ask for it too. And as equal citizens, they have a right to do so. But the fact that a disability itself, rather than an acquired medical condition, can be accepted as a cause for suffering that justifies euthanasia, I find deeply worrying. If the intolerable suffering does indeed result from living with the limitations of intellectual disability or autism spectrum disorder, then it is inevitable that it's hopeless. And that too is evident from the case reports. In cases of persistent treatment refusal or persisting problems despite having tried many different approaches and treatments, physicians tend to reach the conclusion that euthanasia is the only remaining option for the patient. And in fact, many of the case reports were clear in their observation that autism is not a treatable condition, and therefore the patient's inability to cope with life was not treatable either, and therefore euthanasia was a suitable option. Now, bearing in mind the poor record of decision-making by healthcare professionals about people whose capacity is in question, who behave or communicate differently, or whose lives may seem to lack quality, I question whether healthcare professionals are in fact the right people to make decisions about eligibility for assisted dying. Of course, physicians can write clinical reports about the condition in question, and they should do so, but I would argue that the decisions about eligibility should be made in a legal setting, such as a court, after having heard evidence from the healthcare professionals. There are many precedents for using the court to make weighty decisions, such as keeping a person in hospital or moving them to a residential setting against their will, and that would provide prospective monitoring, so before but not after the death of a patient, and that would improve safeguarding. So I'm in no doubt that the patients in the Dutch case report did indeed suffer deeply and consistently. However, we know that people with disabilities experience severe inequalities in opportunities and in health and social care provision, which may well play a part in their situation being hopeless. Current society is not a level playing field where everyone has a full range of life choices and can make autonomous choices about them. So this makes it perhaps all too easy for people to request euthanasia and to be granted such a death as a way out of painfully difficult situations and circumstances, rather than addressing underlying issues of inequality and a lack of adequate support for people with very complex needs. And I'm not convinced that euthanasia was a suitable solution in most of the cases we reviewed. So coming back to my initial question, you need to be able to answer those questions with clarity if you're going to make a sound decision. Is changing the law safer and better for your citizens than not changing the law? And what is your duty of care to citizens with a disability? At what point do you abandon your efforts to improve their quality of life and to offer them an assisted death? So thank you for listening, and I'm very happy to answer your questions.
Merci beaucoup, professeur. Je céderai la parole maintenant au député de Lac-Saint-Jean.
Thank you. Je vois que vous êtes quand même prudente aussi par rapport à la question de l'aptitude à consentir. J'aurais plusieurs questions à vous poser. Je ne suis pas spécialiste là, en la matière. Je vois que vous avez énormément d'expérience et vous avez travaillé beaucoup là, à ce niveau-là. On sait que ce n'est pas un sujet qui est facile à traiter, tout ça. Il y a plusieurs conclusions, il y a toutes sortes d'études. Moi, j'aimerais ça, si vous êtes en mesure de me donner votre opinion au niveau des gens qui ont des déficiences intellectuelles, mais qui sont atteints, exemple, d'un cancer en phase terminale très avancée. J'ai posé la même question tout à l'heure à la personne qui a passé avant vous, qui est accompagnée de graves souffrances physiques. Donc, ces personnes, selon vous, son handicap intellectuel influencerait-il à ce moment son aptitude à consentir à l'aide médicale à mourir? Donc, j'aimerais ça vous entendre. Puis, ça peut être aussi un peu là, au niveau des maladies aussi neurocognitives, là, entre autres l'Alzheimer.
Okay, thank you very much for your question. That is a very good question. As I said in my presentation, people, and the United Nations is quite clear on the rights of people with disabilities, that if a disability should not exclude you from the same rights and the same things as the rest of the population. So in a country like the Netherlands, where 1 in 25 people dies through euthanasia in the Netherlands. Most of those are people with medical conditions such as cancer. And there were a couple of case reports, maybe 2 or 3, maybe not even that many actually, of people with an intellectual disability whose request for euthanasia stemmed from a cancer, from a physical, a progressive physical illness. So I think, as I said earlier, that is a different question for me. So the question whether it is right, a society chooses to allow euthanasia for people with progressive physical illness as cancer is not what I'm addressing here. So your question is, it's a question of capacity. So I think, there were 1 or 2 cases where the description of the capacity assessments, I felt fairly confident that this person did have the capacity to consent to this. It has to be very carefully assessed. But, those cases probably raised the least questions to me. Having said that, I am very aware that we have to be careful that people with an intellectual disability are often much more suggestible to different options. So, and also often have a lifelong experience of feeling a burden on society. And that's a message unconsciously that they get throughout their lives. So I'd want to be really careful that that is not an influence in that person's decision. So you'd have to be very careful that the capacity for decision making is decision specific, that it's that particular decision. And as I say, I think it is possible for people with a mild intellectual disability to have the capacity to make that decision. But I think that needs to be very carefully assessed, and it has to be scrutinized publicly and openly in a place such as a court, which I mentioned in my talk. Does that answer your question, or is that still leaving you a little bit sort of wondering?
OK. Oui. Donc, autrement dit, au niveau de la déficience des personnes avec déficience, on parle des impacts sur la demande anticipée, les balises, puis tout à l'heure, est-ce que vous ramenez ça un peu sur ce que vous disiez sur la décision sur l'éligibilité devrait être prise dans un cadre juridique? Est-ce que c'est ça que vous suggérez vraiment? Puis, est-ce que ça serait, puis d'un cadre juridique, mais est-ce que vous proposez un comité d'experts? Donc, j'aimerais ça vous entendre là-dessus un peu.
Yes, I think so. I think we've, as I said, we've seen sort of throughout all over the world, and the same in the Netherlands with these cases, that medical professionals, doctors, with all the best will in the world, of course they want to do the best for their patients, but they do not have a good track record of making sound and safe decisions for their patients who have disabilities and who have intellectual disabilities in particular, and autism. So I think there are too many examples of the doctor's judgment being affected by their own unconscious bias. There are too many examples of there being even disagreements between doctors about whether the patient was indeed suffering in the way that would justify in the Dutch system euthanasia. There are just too many difficulties with that. So I think I think it needs to go to court, and I think the scrutiny of that needs to be happening before the euthanasia and not afterwards. That's not an issue that is difficult. That if you have euthanasia and then scrutinize whether it was within the legal boundaries, it's too late. The patient is dead, so they can't then sort of be involved in that decision in the same way to whether it was right. So yes, I think all cases should go to court for assisted dying. I haven't yet, and I just want to add this, I don't think there is yet a legal system anywhere in any of the jurisdictions that allow assisted dying that, in my view, guarantees the safety of people with disabilities for that reason.
Thank you. C'est tout pour moi, Madame la Présidente.
Merci, Monsieur le député. Je céderai maintenant la parole à la députée de Saint-François.
Merci, Madame la Présidente. Mrs. Tuffrey-Wijne, I speak in French because my English is not very well.
It's very good. I'm impressed. Better than my French.
Quand vous avez parlé du modèle MacArthur, j'aimerais que vous puissiez élaborer là-dessus par rapport pour évaluer l'aptitude. Donc, et si jamais vous avez aussi des exemples concrets, il y a beaucoup d'intervenants qui nous ont donné des cas précis. Alors, des fois, ça met plus en perspective et ça nous permet de mieux comprendre. Donc, j'aimerais vous entendre sur le modèle MacArthur, s'il vous plaît.
Okay, that's a good question, and it's an important one. I think there are difficulties with using this model, but there hasn't really been another model yet that has been tested enough to see if it would be better. But there is some criticism on this because of the emphasis on a rational decision making. That we know that for many people, when we make decisions, feelings come into it. Even the decision to buy a house, we just love this house, because you can't quite tell why. But it's not particularly logical. But so there is criticism. But at the moment, this is what we have, and so the different aspects of it. So first of all, the patient has to understand the information that is given. In the case reports that we analysed, there wasn't that much clarity about how people with intellectual disabilities, in particular, who will by definition have more difficulty understanding new information, because that's part of the definition of intellectual disability, how they were helped to understand really fully the implication and what is both their illness or their condition, the cause of their suffering, and all the possible treatments or alternatives. And that's the onus of that is actually on the healthcare professional to make that easy to understand, whether that is through you know, through words, to using pictures, through, you know, there's a whole range. It's possible to help people to understand things. But sometimes the decision that somebody lacks capacity is made actually because they might have capacity, but you haven't explained it in a way that they can understand. That wasn't, and I have to say that in all the cases in the Netherlands, the people with an intellectual disability had a mild intellectual disability who could clearly understand spoken words, you know, and communicating words. But the most difficult thing for people with an intellectual disability is this business of issue of weighing up the information, appreciating it. And that you could see is the most difficult for people, for doctors as well to assess. So can this person really not just understand what the options are and the potential alternatives, but apply it to themselves, to their own situation? And so, for example, if you have the woman with tinnitus, it was clear to me reading this case that she wasn't able to apply the possibility of learning to live with it to her own situation. It was completely dismissed because, you know, she was quite rigidly set on the euthanasia option, couldn't consider all these alternatives. So that's important that people can do that. And then they have to be able to reason with it and weigh it up. And again, that wasn't very clear and obvious in many of these cases. The final one is that you have to be able to communicate your choice, that you have to find a way of making sure that people know what it is that you've chosen. So as I said, in many of these cases, you know, the persistence of a request was seen as capacity. They keep asking for it. They seem to know what it means. But actually, these 4 Applebaum criteria weren't particularly met or gone through. So I would have, and in many cases, as I said, different doctors disagreed, and sometimes they had to find a 3rd or a 4th opinion even to see if this person had capacity. I would argue that if there's any doubt, the patient, and now it should really be either go to court or certainly the patient shouldn't be granted euthanasia if there are people who are doubting this person's capacity. Because, as we said, the bar has to be set high for something for which the consequence is so severe, and death is probably as severe as it can get. So, has that explained enough to you, or would you like to know a little bit more?
Oui, merci.
OK.
Autre petite question, si la semaine dernière, on a eu des intervenants comme M. Courtemanche et Dr. Guillaume Barbès-Morin qui définissent dans leur mémoire la décision libre comme étant sans pression. Puis on le voit que probablement, puisque vous avez élaboré, puis l'intervenant avant vous aussi, qu'il y a une certaine pression sociale d'être, je ne veux pas utiliser le mot différent, mais les gens qui vivent avec soit un handicap ou une déficience intellectuelle peuvent sentir cette pression-là, de cette différence-là, puis ils deviennent un peu comme un fardeau pour leur famille. Puis je pense que c'est ça que vous voulez essayer de sensibiliser à dire que ça ne soit pas une voie facile d'être trop permissif dans l'adhésion à l'aide médicale à mourir. Est-ce que vous pourriez nous recommander vraiment des balises claires advenant qu'il y aura un élargissement de la loi?
Yes, absolutely. I mean, I think it's absolutely right. People with disabilities, whether they're aware of it or not, you know, I have many friends with an intellectual disability, and I know from them there is this real sense of not being as worthy as other people in society, not having such as a rightful place in society as other people. So, you know, as I said, that is probably a message they've received subconsciously from babyhood, that you know, that they are a burden, that there is something special about them. You know, one friend I have said, you know, I was also always told I have special needs, but I never really knew whether that was being special was a good thing or not. But it doesn't seem a good thing. So that's definitely that. I think. I mean, for me, you know, as I say, I'm focusing on intellectual disability and autism and looking at these case reports. the main issue is that their suffering seemed to stem from their lifelong disability. And to me, there were comments of people who felt they didn't fit in society. Society wasn't right for them. They couldn't cope with it. It didn't welcome them. They didn't feel part of it. And to me, that is not just a problem within the person. That is a society issue to make the world welcoming and ready for and accepting, not just accepting, but actually fitting for people with disabilities, including autism. It's a very hostile and fast-changing world for people who find those things difficult. And that is, to me, is a question to be very careful that the request for euthanasia or the granting of the euthanasia request does not come from something that is inherent in this person's lifelong disability of being. And as I say, whether it is right for people with progressive advanced illnesses, as cancer, as the previous questioner asked, that is not for me to comment on. That is a different discussion, and I don't feel I have the expertise to comment on that. But my concern is that is really that, first of all, that people with disabilities, there is a danger that it's judged, that they're judged to be suffering to such a degree that it's unlivable with by doctors. And that has happened. We've seen it happen. We've seen it happen in those cases. It happens in UK hospitals all the time. There's many reports like that. But there's also a danger that people with disabilities, as you say, feel an unspoken pressure or an unspoken message that the society, that they don't fit in society, and therefore society is better off without them, and vice versa. And that is, to me, is a worry.
Merci beaucoup. Je céderai maintenant la parole à ma collègue de Westmount-Saint-Louis.
Merci beaucoup, Madame la Présidente. Good morning, Professor Tuffrey-Wijne. It's a pleasure to have you with us. Extremely interesting what you have shared with us today, and I have many questions for you. You've mentioned, for example, that we need to set the bar of capacity very high. I know that you've addressed it with a few of my other colleagues. By all means, if you have other recommendations or other suggestions, feel free to add it. In response to my question, which I have for you is, are you proposing that we establish a two-track model so that there's one that pertains to individuals that suffer from autism or intellectual disabilities as opposed to others, to ensure that there are safeguards and measures of protection in place to protect those that are vulnerable?
Thank you for that question. I'm not sure I can really answer that, but my immediate response is there should not be a two-tier system. That whatever is a danger or a risk for people with an intellectual disability or autism actually would be a risk for everyone. So I want to be sure that everybody has the capacity to make that decision that meets all the 4 Applebaum criteria. The bar is set high, and so that's, I would say that needs to be there for everyone.
Okay.
Yeah.
So you've also suggested that you feel that it shouldn't necessarily be the physicians that are making those decisions, but it should be done more within a legal framework. In advance of getting to that legal framework, I'm assuming that you're also suggesting that there's multidisciplinary evaluation, a round table, a tribunal. What involvement do you see from the caregivers and the families in question? As you mentioned, these individuals are often very easily influenced in the sense of they wish to please. They want to give the answer that they know that the individual is requesting. And so as a mom of 2 kids on the spectrum, I have to tell you that, of course, my influence is going to be the complete opposite. And that's that, sorry, your life is worth living, and I need you.
Yes.
But what happens when I'm not there and that person doesn't have the same sensibilities that I do?
Yes. Thank you so much for that question and for sharing that comes from a personal experience, because you are not unusual. In fact, that is shown, you know, in all our recent inquiries in the UK and in the past for a number of years, that the safety of people with autism and an intellectual disability in hospitals, for example, of being protected from that kind of decision making by healthcare professionals that puts them at risk. Having family and advocates like yourself around protects them from that. And that was a concern we have, and we raised in our paper about these cases, that there was no mention in hardly any of them of family or caregivers being involved. And I think in a decision such as this, they should be involved. This is discussions that should need to be had with everyone, with the healthcare professionals, with the social care professionals, but definitely also with the families and the person themselves, of course. And again, that's why I come back to, you know, if you look at cases that go to the High Court for decision making, for example, should somebody's life support machine be turned off, which is, you know, everybody is involved. It's not just the healthcare professionals who give their evidence, it's also the families. And that all needs to be taken in consideration. So I think when I talk about sort of unconscious pressure, in most, well, certainly the people with an intellectual disability that I've been in contact with and I'm aware of, the families want to keep them alive as much as possible, really, you know. That it's much more an internalized pressure from the rest of society, really, because these, you know, the people with intellectual disabilities, with the most profound disabilities, are so precious in people's families within their lives. And so we have such an important place. Families can see that, but society sometimes can't.
On the flip side of that, though, I think you've mentioned it as well, it's suffering for somebody who's on the spectrum is something that I think many people don't understand, how challenging it is to live in a very sensory world when you have significant sensory deficits, when you are socially isolated, and while you may not suffer from another mental illness per se, it is genuine suffering to feel that exclusion and to feel as though you don't belong and to feel that the world is just constantly against you all the time. So you mentioned that as a potential fail-safe, one of the things that we should have is a prospective monitoring period. How long should that period be? And what if at the end of that prospective monitoring, you have an individual who is clearly able to give consent, has an appreciation of what's happening, and has refused care, and has said, you know what, I still wish to pursue this. This, in your estimation, is still a case that should be going before the courts, and then it becomes a judge's decision whether or not to respect the individual who's on the spectrum or has an intellectual disability to choose.
Yeah, these are good and difficult questions. I think that, I mean, for me, you know, it seems that in those requests and the sort of example that you described, that, you know, you're right. I mean, no doubt that the people in those case studies, particularly with autism, really suffered profoundly. Many also had a psychiatric history, which clearly, you know, people are at much higher risk from because of the issues that you've just described. But, you know, the reason for granting euthanasia, as I say, were part of that, of people's sort of difficulty with coping with this, with the coping strategies, with autistic traits. And I think that needs to be clear. It's clear enough in Dutch law. I mean, there was a court case in 2002, the Brongersma case, which clarified that that the suffering has to have a medical underlying reason that would, you know, for which euthanasia would be allowed, and that can be either psychiatric or somatic. To me, you know, as I say, the issues you described, the difficulty in coping with sensory overload, etc., are not an illness. They're not an illness. They're a way of, they're a part of that person, and therefore, I would, you know, as it stands, and I think as the law stands in the Netherlands, and as far as I understand also in in Quebec, as it's proposed, it's only for illness, therefore for medical conditions that it should be approved. So in my view, these people didn't qualify for euthanasia. You know, as I say, I can't comment on somebody who then also suffers severe psychiatric illness, which some people did, and I don't feel qualified to comment on whether it should then be allowed. Then I would come back to saying that, you know, people, you know, everybody in society has the same rights, but the scrutiny has to be there to make sure that, you know, that the reasons for allowing the euthanasia are the right reasons and fit within the law that we have.
So what happens in the event of a person on the spectrum? And, you know, we've heard the case of changing their minds. Let's say they've gone the route of, they've gone to a tribunal, they've gone in front of a judge, and they have been awarded, that's a terrible word, they have been, the possibility for them to move forward with an assisted death has been given, and it comes down to that moment in time and they change their mind. What then? What do we do?
Then you don't do it. Clearly, yeah. Isn't that clear? I mean, if somebody, I mean, it's the same in the Netherlands. I mean, people, you know, people can change their minds up to the very final moment and have a right and should. I mean, it'd be terrifying if they didn't have that right, because people, you know, things do change. You do change your mind. Of course, if they then would ask for it again, you know, the scrutiny has to be probably even more. Even clearer, you know, that needs to be taken into account of what was it that made that person change their minds, etc. But yeah, I mean, certainly you wouldn't give euthanasia to somebody who doesn't want it at that moment. That would be terrible.
And what training do you think is required for, whether it's professionals in the healthcare, legal system, what do you think is required in order for us to better accompany these individuals along this path, should that be what they choose? Understanding, of course, that consent is, as you mentioned, very difficult process. Of course, understanding and measuring suffering, again, is also a very difficult process. What training should be put in place, and is it the kind of training perhaps that should be mandatory, maybe even for individuals that are going to be supporting those people that have an intellectual disability or autism?
Yeah, I'm not sure I can really answer that question, and I find it because I've seen how difficult that is. I mean, in the Netherlands, there are specifically trained, you know, euthanasia physicians who have, you know, extended knowledge in accompanying the people along this journey. But I can also see difficulties with that, because then it becomes, I mean, maybe normalized is the wrong word, but, you know, it becomes more difficult to see other options if all you see is people who are going to have, you know, want to go and have euthanasia. So certainly, I think, I mean, in the UK, it's very clear there's a new regulation now that people within healthcare systems all have to have training in autism. And that's because of this issue, that wrong decisions have been made, that people's needs are not understood. So that's important. I think anybody on the autistic spectrum or with an intellectual disability needs to be supported by somebody who understands that and who has training in that condition. So it probably needs to be a much wider team that includes the family, people with expertise in the person's condition, as well as sort of medical professionals to comment on their medical state, whether that's psychiatric or physical illness. You know, I haven't sort of thought out any particular form that should take, but I'm quite clear that that needs serious consideration, and that absolutely needs it needs extensive support and training, I would have thought.
Okay. And are there any other recommendations that you wanted to share with us apart from the MacArthur and the Applebaum model in terms of evaluating the capacity? Are there any other recommendations that you would have for us that you think that we need to take into consideration as a recommendation going forward?
Malheureusement, Madame la députée, c'est tout le temps que nous avions. Donc, je céderai maintenant la parole au député de Gouin.
Merci, Madame la Présidente. Merci, Madame Tuffrey-Wijne, de votre témoignage aujourd'hui. Je vais vous poser une question qui va vous permettre de répondre à celle de ma collègue également, parce que ça porte aussi sur la question de l'aptitude. D'abord, j'aimerais bien avoir votre réponse à la question de ma collègue. Et ensuite, deuxième question, et c'est une question posée en toute candeur, parce que je ne suis pas un expert de la déficience intellectuelle et des handicaps. Y a-t-il des cas documentés de personnes qui vivent avec une déficience intellectuelle qui voient leur aptitude légale à consentir à un acte médical évoluer dans le temps? Est-ce qu'il y a des cas documentés de gens qui soit perdent, soit acquièrent durant leur vie, voire même plusieurs fois, leur aptitude légale à consentir? Et là, je pose bien sûr la question, une variation qui serait seulement due à leur déficience intellectuelle. Donc, je mets de côté les cas de maladies, par exemple, neurodégénératives, où on sait que la personne va perdre éventuellement sa capacité à consentir. Donc, est-ce qu'il y a des cas où ça évolue dans le temps? Et si oui, quelles balises doit-on mettre en place pour respecter les droits de ces personnes-là si jamais à un moment X, ils n'ont pas l'aptitude à consentir, mais à un moment Y, plus tard dans le temps, ils acquièrent cette capacité-là?
Okay. That's also a very good question. Just answering your previous question, I think the key points here really are, as I say, to make sure that that the reasons for sort of granting, it sounds awful, euthanasia, are not to do with the disability and the inherent characteristics of that. And as I say, to have for all people, for everybody, to have the scrutiny of the courts beforehand that involves, you know, the whole wide community, if you see what I mean. In terms of capacity and changing capacity, I mean, it's important to know that capacity is both time and decision specific. So the question is, does this person have the capacity to make this decision at this time? And that, of course, can change. It can change with, you know, somebody might not have capacity, but over time, they've learned more about it. They've been given the information in a format that they can understand. They may therefore become capable of making that decision when they weren't before. There may be, you know, it's not an all or something, some nothing concept. So, you know, for example, I mean, I don't know the woman with tinnitus in the case history, but it's possible that she would have capacity to make some decisions, but not that one, because of her sort of fixation with it. So another example is somebody with a needle phobia, for example, or a hospital phobia, might not have the capacity to make the decision to refuse an injection because of their phobia. They can, you know, they would, because they are not able to oversee, really, to sort of engage with the consequences of that refusal. So those sort of things are specific. They might have the capacity to may have other decisions that are actually maybe equally major. And of course, people's capacity. I mean, some people, you know, probably particularly those with more severe and profound disabilities, will not have capacity for those kind of decisions, the euthanasia decisions, at any point in their lives, because they simply do not have the intellectual capacity to weigh up those the implications, and therefore, by definition, almost they would not be eligible for it. And that's therefore you see none of these examples within the case reports in the Netherlands, because you have to request and, you know, have capacity yourself. And of course, it's also possible that people's capacity deteriorates. I mean, you know, dementia is highly present among people with intellectual disabilities. They are at higher risk. So that's possible, and that needs, that's a different, again, it's a different issue altogether. Yeah, and that's, yeah. So does that answer your question?
It does. Thank you very much.
Okay.
Merci beaucoup. Donc, nous allons passer la parole à la députée de Joliette.
Hello, thank you very much for your presentation. I'll pursue in French. Peut-être juste dans le contexte, là, si ça peut vous rassurer, dans la loi québécoise, donc du Québec, le handicap ne donne pas lieu en soi à la possibilité de demander l'aide médicale à mourir. Il faut vraiment une maladie grave et incurable. Et le mandat de notre commission n'est pas non plus d'envisager ça. c'est vraiment, tout est à partir de la question de l'inaptitude. Alors, c'est pour ça qu'on pose beaucoup de questions sur ça. Et là-dessus, je me doute de la réponse, là, mais je voudrais juste que ce soit très clair. Pour une personne qui est vraiment jugée inapte, mais qui pourrait, parce qu'elle a une maladie grave et incurable, que ce soit une maladie neurodégénérative, que ce soit un cancer, avoir accès à l'aide médicale à mourir parce que les autres conditions seraient remplies, mais évidemment pas celles de l'aptitude. Est-ce que, selon vous, on doit exclure le consentement par une tierce personne en toutes circonstances?
Yes, is the answer to that. I think that should be absolutely, they should be absolutely excluded from the possibility of having an assisted death. If they cannot themselves consent to it or have the capacity to understand, then it should absolutely not be possible for anybody else to make that decision for them. That's very clear in Dutch law, in my mind. And I just want to come back to what you said before, that in Canadian law, it's only people with a physical illness who qualify.
Not in Canadian law.
Sorry,
au Québec.
Quebec law.
Il y a une différence entre le Québec et le Canada. C'est pour ça qu'il y a une confusion.
Oh, no, I do apologize. I'm learning. Right? So, but I just want to say that that is actually the same in Dutch law. It doesn't completely reassure me, and that is my worry, that however clear the law is that it is only certain conditions or certain circumstances, it does put people with disabilities at risk. Because as you could see in those cases that I've described, of the way that physicians and the person themselves might interpret or describe their illness. So even, people with autism, is that a progressive thing? I mean, for the people and the cases in the reports, their symptoms or their characteristics got worse and worse. But that was almost progressive, the way their lack of coping with it. So it may well be clear on paper, but in practice, it is not clear, and that does put people at risk. And that is something to really be aware of, I think, and to be careful of.
Très bien. En fait, vous nous dites ça parce que vous dites qu'il peut y avoir une confusion chez les soignants, chez les médecins, à savoir est-ce qu'on est dans une maladie ou dans une autre circonstance, et vous dites qu'il y a encore du travail à faire par rapport à ça, si je vous comprends bien. Ouais.
That's right. And I just want to just come back, for example, that woman in her 30s who had a brain tumor, who had an intellectual disability, had a brain tumor, is now in remission, still has symptoms that may seem like a physical illness because it may be related to the brain tumor. They didn't think it was, but it could be. To me, that suffering that stemmed from her disability, the way that she found difficulty coping with her illness. So it is a difficult thing to judge, and I think it is dangerous for people with a disability, really. So that's my concern.
Merci beaucoup.
Merci beaucoup. Donc, nous passons à notre dernier intervenant, Monsieur le député de Chaumédé.
Merci, Madame la Présidente. Madame Tuffrey-Wijne, welcome. It's a pleasure to hear about you, and it's the brief is also very interesting. I'm a little bit preoccupied by the point about the professional. I think that we may think of putting some specific criteria in our report or in the review of the law to avoid any I won't say error, but to avoid any report who will not reflect the reality. And regarding that, and I'm going on the same side that my colleague from Westmount St. Louis, I don't know if you have some suggestion, especially regarding professional, but it will be more than welcome for us.
I'm not quite sure I completely understand your question. So is it what advice you have for professionals to make sure they make the right judgments? Is that what you're asking?
and that we allow I would say that in French, that we allow le poids de leur rapport. Est-ce que nous allons utiliser leur rapport pour être sûr qu'il n'y aura pas d'erreur ou pour être sûr qu'il n'y aura pas de complaisance dans leur rapport? Je vous demandais si vous aviez des suggestions spécifiquement ou certains critères spécifiques pour être bien sûr que le diagnostic des médecins seront toujours les plus factuels possibles.
Okay. Yes, no, I think that is important. But again, I think the Dutch case reports demonstrate just how very difficult that is, because they, so physicians have to write this report. They have to write to the Euthanasia Review Committee what the suffering consisted of, why they thought that it was hopeless and without prospect of improvement. And they have to ask a second opinion from an independent physician who then doesn't necessarily need to agree. They just have to ask this opinion. And that just shows how very, very difficult that is and how important to go into detail. So the case reports where the doctor, sometimes the physicians were called into the committee and questioned further and explained further. And those were far more illuminating. And that just goes to show in how much detail actually you need to report that, your assessment and what you've done. So I think that's important. And the difficulty is in this, as I said, that happens after the patient has died. All these questions that have been raised. If there's so many cases that raise these questions, it shouldn't happen after the patient dies. It should happen before. So I would want to see that scrutiny and these doctor reports and even the debates and the discussions between physicians to be public if the decision that hinges on it is so dramatic, which it is. So I think the more they can describe and report, and maybe again that's why it needs to go to court and report it, because that is all transcribed and then everybody can help to see what's happening.
If I may,
Merci.
Madame la Présidente. No,
merci beaucoup, Monsieur le député. Merci beaucoup. Merci beaucoup, professeur Tuffrey-Wijne, d'avoir accepté notre invitation aujourd'hui. Et sur ce, la commission ajourne ses travaux et nous reprenons dans quelques instants en séance de travail. Donc, merci beaucoup, professeur Tuffrey-Wijne.
Okay, thank you.